Suggestions, recommendations for reforming the court system. 1. The court system needs judicial reforms. Cases should be heard on merit, and there should be a specific time frame for the settlement of cases. Cases should not linger on for generations. 2. Increase the number of judges. The number of judges must be doubled at least. 3. Expanding the sphere and number of model courts. 4. Interinstitutional accountability for judges. 5. Ultimately, it is the constitutional duty of the superior courts to oversee day-to-day proceedings being conducted in the lower courts and arrange for continuous training sessions. 6. Similarly, Austin's command sanction theory should also be employed to make the learned judges work properly. The threat of being removed from office for poor performance would be enough for most of them to work. 7. Ethical training is also essential for judges. It needs to be instilled into the hearts of the judges that every stroke of their pen, each day, writes the fate of hundreds. Somebody is deprived of their rights, whereas sometimes some are rewarded with what is rightfully theirs. And 8. The government should set up a free judicial assistance service that will ensure to provide legal help to those poor litigants who cannot afford exorbitant fees of lawyers. 9. The government should set up more criminal courts at district and tehsil level to provide cheap and speedy justice at the grassroots level. 10. For a speedy and fair trial, Pakistan needs a separate special investigation department in the police. It shall be under the direct supervision of the district police officer, but their main duty shall be confined to investigations. Qualification should be a degree in law, and such police shall be trained by competent judges and lawyers in judicial academies to teach them special techniques and skills. A collection of evidence by such police will be authentic and accurate, and will facilitate a judge to reach a decree. 11. Subordinate judiciary in Pakistan at the district level is itself a hurdle in the way of speedy justice. It is hosting 3 kinds of problems: insufficient number of judges, recruitment of inexperienced officials, or functionally illiterate judges with no specialization over the civil or criminal branch. 12. Specialization and expertise over criminal or civil branches of law are also points of great concentration. Such options shall be given to them in the initial phase of training in judicial academies to pick one field of their choice willingly, and then expert lawyers of relevant fields, civil, criminal, shall be called in to guide and teach them about the technicalities. They shall perform their duties in the specialized field till retirement. This will significantly help in the speedy delivery of justice. 13. Most judges in district courts are fresh graduates of law having no vigorous practical experience as a lawyer. Such fresh graduates face problems in dealing with complications of cases of complex technical nature. Hence, a mechanism is required to be devised for this problem. 14. Time limitation for a declaration of the decree for both civil and criminal cases needs to be introduced. For this purpose, our parliamentarians are required to do legislation in which they specify a specific time for judges for case remedies and bind them not to postpone unnecessarily. The specific time must be reasonable, not too short to defeat the maxim, justice hurried is justice buried, and not so lengthy to defeat the concept of justice delayed is justice denied. Such kind of legislation shall also bind the lawyer fraternity to represent its plaintiffs on the day of hearing strictly. 15. Protection of judges and their families is crucial, especially in sensitive or high-profile cases. 16. The introduction of a protection of witness program is also critical, especially in criminal cases, in line with the model of the U.S. Witness Security Program, WITSEC, which is protected under the Organized Crime Control Act of 1970. The roles of witnesses in criminal and civil cases are that of a backbone. In the event of non-protection, witnesses prefer to avoid providing testimonies out of fear. 17. The inherent power of adjournments of proceedings should be used very rarely. It should be allowed only in exceptional cases and then not more than once. 18. The incumbent Chief Justice of Pakistan, with the help of the government, is required to take the problem of delayed justice seriously and discuss it with bars, eminent jurists, and lawyers to derive out a permanent solution for it. 19. Using probation as an alternative to conviction will also reduce the burden and pressure from the court system and help first time offenders reintegrate into society again.